Hello, my name is attorney Masa Sam Foray, and I am founder of the Foray firm with offices in Chicago and in Houston. And I am back again today to answer all of your Illinois family law matters. So today's question is, how long will my divorce take? And honestly, the answer to that question depends on the facts. If you guys have a case that is highly contested, meaning you hit all of the hot button topics, including not only dividing the debts and the assets, but also dealing with matters of custody, or what we now call allocation of parental responsibilities, then your case could last honestly an indefinite period of time. In fact, for very contracted custody cases, it would not be uncommon in the Chicagoland area for those cases to last upwards of 2 years or more. But if you guys are amicable, if you can work out an agreement, and those two things are obviously well within your control, then you can fall on the shorter end of the spectrum. So let's talk about some of the things that you cannot control. Number one, prior to the entry of dissolution of marriage. So not prior to when you file, but prior to the entry of the final divorce decree that's actually signed by the judge. One of you must have lived in the state of Illinois for at least 90 days prior. So if you haven't lived in Illinois for at least 90 days prior, that right there lets you know that you have to at least wait 3 months to get your divorce. Also, because it's against public policy for people to get divorced as easily and as quickly as they break up, right? There's a public policy interest in making sure that families stay intact and that married people, especially people with children to consider, do their very best to try to work out their differences. So when you tell the court that you have reached an impasse and that you have irreconcilable differences, the court is definitely going to ask you whether or not you have made attempts. That is asked universally at every prove up or every final divorce case hearing. Have you made attempts to reconcile? And do you believe that future reconciliation is futile and also not in the best interest of your family? And so therefore, a cooling off period, if you will, is written directly into the statutes. So in the IMDMA, or the Illinois Marriage and Dissolution of Marriage Act, there's actually a 6-month waiting period, and that's 6 months of separation. Now, I will tell you that separation does not necessarily mean that you have to be physically separated. You guys don't have to be legally separated. There doesn't need to be any legal separation document. That almost never occurs. And you don't even have to be living in separate residences. Separation within the meaning of the statute just means mentally separated, meaning the marriage is on pause mentally. And that could be subjective to one party. One party might say, it was that very last huge fight we had on Valentine's Day that really caused the separation. And another party can say, it was the last time, he came home too late. He came home in the middle of the night. That's when I knew the marriage was over for me. Nevertheless, if the court inquires, you do have to give a reason as to the date that you chose. And in no event is the court going to, allow the divorce to happen if you don't attest to at least 6 months of separation. In addition to that, if you have to serve the person via publication, meaning that you don't know the address of the other litigant, you're the petitioner, you don't know the address of the respondent. Maybe you've actually been physically separated for a number of months or a number of years, and you just literally have no idea where they've been living since they, moved out a few years ago. And then you can ask the court to allow you to do service via publication, meaning service in the newspaper. When you do service in the newspaper, you have to allow that service to run for a requisite number of weeks. And if the service does not run and you don't get a certification for the requisite number of weeks saying, yes, we certify that we put, Mary Smith's petition for dissolution of marriage and the notice of the summons and the filing of that case in the newspaper on this date, and this date, then the court is not going to divorce you until you get that certification affirming that you gave the other person, the respondent, the opportunity to see the newspaper, be notified about the proceedings, and then appear and be present for the proceedings. So that'll also cause a bit of a delay. Nevertheless, We at our firm, and I'm sure many other, experienced family law attorneys have had people divorced literally within 2 to 3 weeks from the day that they first meet us. So from the day that you've come into the office for a consultation to the day that you actually get your finalized divorce, it can go as quickly as, 2 to 3 weeks. It can be 30 days or less. That requires an agreement by both parties. It requires an acknowledgement of the divorce going on, an acceptance of the divorce paperwork. So you're not spending time having to serve somebody in the newspaper, and you're not spending time having to have the sheriff go out and look for them to serve them personally with the summons. So it definitely does take an agreement from both parties. But as long as both parties are willing and ready to quickly work together to draft the documents and the terms of the documents and then sign them and get them filed, it's not impossible to be divorced as soon as possible. So the length of your divorce is going to vary from case to case. And more importantly, it's going to depend upon your willingness and the co-willingness of your soon-to-be ex to move forward in an expeditious manner. I hope that this video has been informative, and I look forward to seeing you on the next one.